Welcome to this video on birthright citizenship, where we ask, who decides what it means to be American? Birthright citizenship. It's one of the most contested questions in American law today. But beneath the court cases and executive orders lies a deeper question. Who gets to decide what it means to be American? In this video, we're going to explore why this debate cannot be settled by politicians, presidents, or even the Supreme Court alone. The answer ultimately belongs to the American people. The Constitution is the people's charter, not a party's platform. Citizenship is not a decree of rulers, but a covenant of the people. For 125 years, the 1898 Supreme Court ruling in United States v. Wong Kim Ark was considered settled law. Children born to non-citizens on U.S. soil were citizens, but the sustained influx of undocumented immigrants and the rise of birth tourism have fractured that consensus. This forces a profound constitutional question. Does the mere act of setting foot on American soil, even temporarily or without consent, automatically create a permanent claim on the nation's resources? Administrative fiats and legislative maneuvers cannot resolve foundational questions of identity. When tested against the Constitution, every modern workaround shatters. Executive orders are fleeting and partisan. They attempt to settle constitutional text through temporary administrative fiat and are routinely blocked by lower courts. Criminalizing birth runs into the Eighth Amendment and equal protection. It punishes the mother's biological act to indirectly target the child's status. And mandatory visa contracts violate the unconstitutional conditions doctrine, forcing individuals to surrender fundamental Fourth and Eighth Amendment rights for entry. None of these work. The landmark 1962 case Robinson v. California established a core principle. The government cannot criminalize a status or a biological condition. Childbirth is a legal, protected act for the broader public. To criminalize it for one specific class of people, undocumented women, constitutes a severe violation of the Equal Protection Clause. You cannot punish someone for who they are by targeting a natural, universal human function. The government cannot force a person to waive fundamental constitutional rights in exchange for a benefit like a visa. So-called visa contracts that demand a guarantee not to give birth trigger massive constitutional violations. They violate bodily integrity under the Fourth Amendment and proportionality under the Eighth Amendment. A $1 million fine for giving birth, a legal act for citizens, is grossly disproportionate. This is not a contract, it's coercion. Proponents of reform increasingly invoke Article 4, Section 4 of the Constitution, framing unauthorized birth as an invasion that depletes public resources without sovereign consent. The government's argument is that jurisdiction requires allegiance and consent. But the counter-argument is historic and chilling. Tying personhood to permission recreates the exact legal system the 14th Amendment was explicitly written to overturn. The logic of the Dred Scott decision, where certain people had no rights the state was bound to respect. This reframing, while powerful, carries deep risks. The Supreme Court faces a binary choice. It can reaffirm 125 years of precedent, ruling that anyone subject to U.S. laws is subject to the jurisdiction of the United States. Or it can reinterpret the 14th Amendment to exclude children of undocumented immigrants, effectively rewriting the Constitution from the bench. But neither option settles the debate. Judicial reinterpretation will only inflame partisan divides, and it remains subject to reversal the moment the court's composition changes. The courts cannot resolve a question that is fundamentally about national identity. A constitutional amendment is the only mechanism that carries the weight of the people's consent. It requires a 2/3 vote in both houses of Congress and ratification by 38 states. Whatever the outcome, finality is achieved. If an amendment fails, the American people have spoken. Birthright citizenship remains a core, non-negotiable value. If it passes, the nation shifts from a territorial model of citizenship to a consensual, lineage-based model. Either way, the decision belongs to the people, not to politicians or judges. Citizenship is not soil nor decree, but the voice of the people. The decision over birthright citizenship is not for a party to dictate, a president to decree, or a court to divine. It is a choice reserved entirely for the American people. Is belonging a matter of geography, or is it a matter of consent? That question will only be answered when the people speak through the hardest, most democratic process the Constitution provides. Anything less is not a solution. It is merely a delay.